court docs for Bree and 2K's trial. I'm good, love. This is for their trial, just kind of the last minute stuff. Trial starts next Friday. On the 22nd is the first day. These are all, I'm pretty certain these are all filed by 2K's attorney. Okay, here we go. So again, during these, I always have to do my thing. Make sure you guys are tapping, send your daily heartbeats if you haven't. You never have to send gifts, but if you could, or if it starts lagging, whatever the case may be, that's the time to do it, because people like to come in and report. Okay, so this is this is John's exhibit list. So it says, to the court and to respondent and her attorney of record, please take notice that petitioner John, by and through his attorney of record Taylor, hereby submit the following preliminary list of exhibits he intends to offer as evidence at the time of trial in this matter. This is a long one. Number 1, petitioner's request for DVRO filed 5/3/24. Number 2, petitioner's reply declaration filed September 10th, 24. Stipulation and order filed 10/31/24. And mods, because I have my head down, if questions come up, if you guys can try to answer them, or if they're pinned, then I can, like, as I pick my head up, I can kind of look. But for the most part, I'm going to have my head down and just reading, because I want to get through these, and there's a lot. Okay. Number 4, 10/31/24, hearing transcript. Number 5, October 30th, 24, hearing transcript. 6, September 17th, 24, hearing transcript. 7, notice declaration filed in support of petitioner's ex parte request for order of January 15th, 25. Number 8, petitioner's ex parte request for order filed January 15th, 25. Number 9, petitioner's request for order. What's happening here? For order filed January 15, 25. Number 9, petitioner's request for order RE entry of Nuke Pro Tunk order, whatever that is, filed January 16th, 25. Number 10, March 17, 25 minute order. 11, substitution of attorney filed December 3rd, 24. Number 12, proof of electronic service, RE, petitioner's RFO filed January 16th of 2025. Petitioner, number 13, petitioner's declaration, RE, ex parte notice given filed March 24th of 25. 14, petitioner's ex parte request for order filed March 24th of 25. 15, ex parte order issued March 24, 25. 16, petitioner's request for DVRO filed March 27, 25. 17, petitioner's exhibit filed March 27th in support of request for DVRO. 18, temporary DVRO issued March 27th. 19, petitioner's supplemental declaration filed April 2nd. Number 20, February 19th, emails exchanged with respondent. 21, March 18th, emails to respondent. Okay, let me go to the next page. Oh, here we go. 22, March 19th, emails to respondent. 23, March 21st, emails exchanged with respondent. 24, March 22nd, emails with respondent. Number 25, TikTok of respondent's boyfriend threatening petitioner. Neza. Number 26, TikTok of respondent threatening petitioner's family. Number 27, TikTok of respondent discussing missed court appearance of 3/17/25. If you guys remember, that's a day she said, I didn't miss court, I just didn't want to go. I just wasn't feeling it. I was kind of over it. Okay, so that's that day. Number 28, TikTok of respondent in a physical fight. 29, TikTok of respondent in a verbal altercation. Number 30, social media video of respondent verbal abuse of petitioner. Number 31, TikTok of respondent verbal abuse of petitioner threatening his mother. 32, video of respondent's appearance on single mom attorney podcast. It's getting good. Okay, let's go. Mind you, I'm not going to toot my own horn, but toot toot. Single mom attorney was not going to post that. Remember, they did it and she was not going to post it. And I messaged her and I said, why would you not post that? You're the one and only person I feel like that could ever, that would have any change or whatever. El Cam, thank you so much, love. That is so beautiful. And at first the attorney thought I was like kind of dissing her. I said, no, I'm not. But anyways, so she ends up posting it. Anyways. And that was, somebody asked what the last one was. That was her Bree's appearance on the Single Mom podcast. Number 33, social media account created in the name of respondent's derogatory nickname for petitioner. Oh, I don't know anything about that. 34, TikTok of respondent threatening to F up petitioner and his mother. 35, TikTok of respondent calling him too gay. 36, TikTok of respondent mocking petitioner. 37, TikTok of respondent harassing statements about petitioner. 38, TikTok of respondent petitioner too gay again. 39, TikTok of respondent making harassing statements about petitioner. It's funny, this is a long list of TikTok stuff, but let's not forget, remember how she kept saying they can't use the social media, they can't use this. They can't use this. They can use, I kept telling you that they can use it. They're going to use it. They're using it. Let me see. TikTok of respondent discussing intimate relations with petitioner. TikTok of respondent making false statements about petitioner's home, calling it a trap house. 42, TikTok of respondent admitting to posting with the intention of upsetting petitioner. Thank you. 43, social media post of respondent discussing the kidnapping of her kid. I'm trying to think right. Beating up his mom. 44, TikTok of respondent stating petitioner likes men. Thank you, Angel. Number 45, TikTok of respondent stating petitioner is gay and discussing intimate pictures. 46, TikTok of respondent threatening to kidnap again. Okay, here we go. 47, Snapchat respondent, so Bree's Snapchat, admitting to posting content to stir shit up, in quotes. Snapchat image, respondent calling petitioner a shitty baby dad. 49, TikTok respondent addressing petitioner's counsel. Remember, you guys, we were worried, or we were wondering, not worried, we weren't worried at all. We knew it happened. If they were going to bring up the stuff about talking about counsel and the judge. So I'm waiting now to see if the judge piece is going to come in there. Snapchat image respondent making harassing statements about petitioner. Snapchat image respondent calling petitioner's residence a trap house again. Social media message respondent sharing petitioner's intimate photos. Oh, that could be a whole charge. I mean, I haven't seen the photos, but that could be issues. 53, TikTok of respondent stating petitioner likes to, I didn't hear this either, stating he likes to grape girls. Number 54, TikTok of respondent talking about bringing W back to LA and kidnapping him again. 55, TikTok of respondent talking about W coming back to LA soon. 56, social media recordings of respondent threatening to F you up and burn your MF city down. Listen, we can't say we didn't try to tell her, honey. We tried to tell her exactly what was going to happen. She didn't want to listen. I'm reading the the exhibit list that for 2K. I'm right. There's several documents, but this is the exhibit list. Okay, number 57, TikTok of respondent NW in LA, March 24th. 58, TikTok of respondent in LA, NW in LA, stating she hopes petitioner attorney gets in a car crash. This girl has lost her damn mind. 59, TikTok of respondent showing 3/17, 25-minute order. TikTok, oh my God. Number 60, TikTok of respondent reading email from petitioner's counsel. You guys, that's a video of her reading that she's not supposed to take Baby W out of Dallas. And then what she do, she took Baby W out of Dallas and took him back to California. Number 61, TikTok of respondent reading the 3/17-minute order. 62, TikTok of pole dancing in respondent's residence while W with respondent in LA in violation of court order. 62, video showing respondent's kick post labeled as leaving W with pedos. No, I didn't see that either. It says a video. I'm going to read it again. Video showing respondent's kick post labeled as leaving W with pedos. That was 63. Respondents kick stream March 25th. So now they're putting in all the kick stream of the whole time he was there, I'm assuming. But we'll keep reading. Okay, respondents kick stream March 25th. Number 65, recording of respondents threatening to steal W again. 66, recordings of respondent threatening to kidnap W from supervised visits in Dallas. Oh my God. Steph, stop it. 67, recording of respondent refusing to return W, threatening to kidnap him again. 68, TikTok of respondents calling petitioner broke baby daddy, threatens to go on a kidnapping spree, among other harassing statements / verbal abuse. 69, TikTok of respondent mentioning a plan to get W back, then boyfriend's released from jail, following events 3/25/25. Number 70, TikTok of respondent threatening petitioner's mother, calling him a gay-ass B. Gay-ass bitch, I don't know if I can say it or not. Among other things / verbal abuse. 71, TikTok of respondent discussing the March 27 DVRO filing. TikTok of respondent calling petitioner a bitch after, thank you, L Camp, a bitch after attempted service of the DVRO. Oh, so they put the video in of her ducking. Remember when they kept trying to serve her and she kept trying to duck it, and then she came on, she was like, she called John a bitch and mocked him about not being able to get her served. TikTok of respondent admitting to trolling the petitioner. 74, respondent's boyfriend showing up to petitioner's hotel threatening to fight him in June of 2025. TikTok of respondent and respondent's boyfriend threatening to fight petitioner again. 76, TikTok of respondent playing subpoenaed police footage. Remember we talked about that too, you guys? How when the police footage was released and whatnot, if that was going to come back to bite her. 77, TikTok of respondent referencing police report for DV incident with current boyfriend. Remember we talked about that too. They kept saying they won't use it, they won't use it, they won't use it. I'm like, they're going to use it. They're going to use that. They absolutely will use his DV against you during this time period. They're using it. They submitted it. 77, TikTok of respondent referencing police report for DV incident with current boyfriend. 78, Snapchat story respondent's boyfriend harassing petitioner in August of 2025. 79, long list. Recording of respondent and her boyfriend discussing violation of March 17, 2025 order harassing petitioner in August of 25. Number 80, TikTok of respondent's boyfriend threatening petitioner's witness in July. Wait, TikTok of respondent's boyfriend threatening petitioner's witness. Wait, who would that be? So Santos was threatening one of 2K's witnesses? Who was that? Oh, Lena. Oh, John's mom? Oh my gosh, all the names. Could be any of them. Oh, was he on there with... Yeah, it's probably either Lena or Funeral. Okay. Which one was that one? Okay. 81, March 25, TikTok of respondents, boyfriend with W. Literally. 82, respondent sharing inspiration. Wait, what? TikTok respondent sharing inspiration for bikini line. What was the inspiration behind that? Do you guys know? Oh, it's Funeral. Okay, thanks, Sneak. That makes... I think I did see him on there. Right, the thing is good boy, but what was the inspiration behind it? Just her calling John always a good boy? Okay, got you. Okay. Dumb. I mean, just little things like that. Okay, 83. TikTok respondent's boyfriend taunting petitioner's sister. Jesus Christ. And she wants to take Santos to court with her. Like, let's get it together. Let's get it together. 84. Excel spreadsheet of petitioners, so it's John, expenses incurred in connection with either party's parenting time in California from April 24 to November 24. 85. Complete record of Our Family Wizard messaging, messages exchanged between petitioner and respondent. If anyone doesn't know, Our Family Wizard is an app that court uses for parents to be able to communicate with each other back and forth. And the court automatically gets all of those records, and it's to keep, everything civil. So, she called Jacob. Oh, that's right. She did. That's how it started. Okay. How crazy is that? It's those little things like that that just don't make sense. You've been accused of kidnapping the kid, and then you take the baby back and you start good boy because he didn't do anything. Well, all he was there was to get his child. And then you talk about how you name your bikini line after that. Like, that's not going to affect your case. Anyways. 85. Complete record of Our Family Wizards. We did that. 86. All professionally monitored visitation reports for respondent supervised visits with the minor child. And 87. Various photograph depicting petitioner's custodial time with the minor child. Let me turn off request. And the minor child's lifestyle with petitioner. Petitioner reserves the right to amend this exhibit list through the time of trial and to offer any and all rebuttal and or impeachment exhibits as necessary or appropriate. So that's just the, okay, Nikki, we'll watch that. So that's just, no, she definitely is not going to be charged for the napping, you guys, because the court itself messed up. They didn't serve her correctly. Thank you, Heather. Wait, what's that? I just had something I want to say, though. Where was I going to go with that? I lost what I was going to say. It'll come back. Oh, you're good, love. Did they list things when W was a newborn? No. Now, she may. That may be on her list. Oh, I had something so important to say and I can't remember it. Well, it probably wasn't mentioned because if you... Leanne, thank you. That was so cool. Remember, the judge put a timeline, right, of the dates. Now, if something super major came up, and again, there's so much information already out there to where she's legitimately screwed. I have said from the very beginning, the first video I ever did, she is her own worst enemy. She is just wrapping this case up with a pretty little bow and just handing it over to John. Those are not in there. That's not there. Now, that doesn't mean that it can't be changed. He can still add things. But as of now, that wasn't in there. Maybe they weren't able to validate them. Maybe it wasn't something because she didn't post them, right? All of these things are stuff that she posted herself. So there's no way to say that it was changed or altered by other people is what I'm assuming. Do I think she'll get some type of custody? No. Do I think she'll get some type of visitation? Yes. Not out of Texas, though. Okay, so let's see. So this is the, this is John's trial brief. She was served by email, Queen Bee, but she hadn't signed the paper that said that. But he did put in here, oh, was there no jumper number 79? Hold on. Oh, I didn't know. Because it doesn't say. It just says recording of respondent and her boyfriend discussing violation of March 17, 2025 order harassing petitioner August 25. So that, I mean, that could have been anything. But yeah, that could be it. There was something I wanted to say, though. Okay. We'll move on to the next one. It'll come to me. So this is page 1 of 13. This is John's trial brief. I'm going to stand for a second. Hold on. Oh, maybe not. I don't want to move everything. Okay, we're just gonna thug it out, push through. Okay. All right, it says to the court and to respondent and her attorney of record. Oh, I don't know. Pause. Oh, thank you. That just reminded me what I was going to say. So, anyone see any coincidence? I won't. Thank you, love. Anyone see any coincidence that this came out today of all of the stuff that's been out on social media that's going to come up, and all of a sudden today, supposedly, she's retiring from social media? Or do you think that's just another, just another, who knows, right? The first day of trial is August 22nd. It's 4 days. Okay, so here is his trial brief. Petitioner John hereby submits the following trial brief for the purpose of setting forth his request relief at the evidentiary hearing on petitioner's request for permanent DVRO against respondent and petitioner's request for custody move away order. Did you guys hear that? Request for a permanent DVRO. Okay. Number 1, statistical facts. 1, parentage petition filed April 30th of 24. Number 2, respondent of petition filed none as of August 11th, 2025. Note, respondent first made a general appearance in this matter on July 3rd of 24 when she filed a responsive declaration to petitioner's request of order. Number 3, minor child W, born such and such days, herein will be responded as, it says his name as the minor child. Number 4, custody and visitation orders currently in effect. Sole legal and sole physical custody of the minor child is awarded to petitioner in Dallas, Texas. Professionally supervised visitation is awarded to respondent in Dallas County, Texas, as set forth in the A, May 2nd, 24 order. As to the dates and details of respondents' professionally monitored visits. B, the temporary DVRO issued March 27th of 25, granting petitioner's DVRO request in part and maintaining the March 24 ex parte order hold on. I do have to. Sorry, guys. Let me just scoot this back a little so I can stand. Sorry. Okay. Better. Okay, see, ex parte order issued March 24th of 2025, awarding sole legal and sole physical custody of the minor child to petitioner, ordering professionally monitored visits to respondent in Dallas County, Texas. D, March 17th, 2025, order limiting respondent's visitation with the minor child to the state of Texas. E, October 31st, 24, stipulation and order establishing primary physical custody of W with petitioner in Dallas, Texas, awarding 1 week periods of visitation to respondent in Los Angeles, memorializing terms related petitioner's agreement to voluntarily dismiss his prior DVTRO request without prejudice. Number 5, current child support order in effect, none. And then the 2 on that is petitioner's relief requested at trial. 1, this is what he's asking for. 1, grant petitioner's request for permanent DVRO order against respondent. Petitioner's request includes, but is not limited to, the issuance of general restraining orders not to abuse, and more specifically, that the court find the respondent has utilized social media to perpetrate abuse of petitioner as defined by the the Domestic Violence Prevention Act, and that such abusive speech is not the type of speech that is protected by the First Amendment. Petitioner in thus also seeking the issuance of restraining orders prohibiting respondent from discussing petitioner directly or indirectly, including by way of nicknames, the petitioner's mother, with whom petitioner resides on social media, defined as websites with applications that enable users to create and share content or to participate in social networking for the duration of the time that the permanent restraining order is in effect. Number 2, maintaining the existing orders awarding petitioner sole legal custody and sole physical custody of the minor child, as discussed herein below. The requested orders are the best interest of the minor child, including pursuant to Family Code Section 3044, Family Code Section 3011, and Family Code Section 3020. Number 3, maintaining the existing orders awarding respondent supervised visits in Dallas, Texas during 1 week each month. As discussed herein below, the requested orders are the best interest of the minor child, including pursuant to Family Code Section 3044, Family Code Section 3011, and Family Code Section 3020. Subsection 1 of that. It is anticipated that respondent will accuse petitioner of seeking the aforementioned relief because he just wants to cut respondent out of Winter's life. To be clear, petitioner would be open to discussing a step-up schedule in the future, which may include a move toward visits that are supervised by a non-professional monitor of petitioners choosing and or unmonitored visits still in Dallas County, Texas. However, petitioner's willingness to contemplate any such step up in the future would be contingent upon respondent first demonstrating a consistent ability to adhere to all of the court orders in effect, including any and all permanent restraining orders issued after the... Thank you, Angel! Lost my spot. I got so excited, lost my spot. Okay, including any and all permanent restraining orders issued after the evidentiary hearing, as well as consistent adherence to any supervised visitation rule. Now, let's not forget, you guys, even though W very much likely was not at the center when she just posted the video of him being at the where her visit was at, that very much could be in violation as well. You just showed where you were having your visits at. So, subsection 2. At this junction, petitioner contends that any modification of the existing violation order, whether to non-professional and or unsupervised visits for respondent or visit outside of Dallas County, is premature and would be detrimental to W's best interest. But for respondent's own actions since October 31st, 24, which include but are not limited to repeated public via social media displays of significant substance abuse abuse issues, as well as a recurrence of respondent's abusive conduct toward petitioner and repeated violations of court order, such as respondents twice removing the minor child from the state. Give me 1 second. Let me just turn the fan on. It's like 90 something degrees today. We have air conditioning, but still hot as heck. Okay. Now I can focus. Let me go back. Hold on really fast, just because this is mid-sentence. Okay, I'm just going to read whole subsection 2. I know, thank you. If I'm standing, I'm feeling a lot better. It's the sitting that really does it. You guys, for those of you guys just coming in, these are the, this one is the trial brief. We just did the evidentiary thing for John. This is what John's side has submitted. Okay, so I'm going to do subsection number 2 again because I didn't know I was stopping mid-sentence. At this juncture, petitioner contends that any modification of the existing visitation order, whether to non-professional and or unsupervised visit for respondent or visit outside of Dallas County, is premature and would be detrimental to W's best interest. But for respondent's own actions since October 31st, 2024, which include but are not limited to repeated public, via social media, displays of significant substance use / abuse issues, as well as a recurrence of respondent's abusive conduct towards petitioner and repeated violations of court orders, such as respondent twice removing minor child from the state, in which her visits were required to be exercised without telling petitioner of the minor child's whereabouts. It is likely that petitioner would have been comfortable adopting the October 31st, 24 stipulation and order as the final custody of visitation orders in this case. The only reason petitioner is seeking the orders he is seeking is because they are necessary at this time for the protection of the party's minor child. Petitioner remains hopeful that the respondent will, again, for people that, I'm going to read this sentence here, but for people that are saying that John is a horrible parent and he's doing all this stuff and trying to take the mom, like, he is absolutely positively not. He is doing everything that he can to put her in this position. It says this right here. The only reason petitioner is seeking the orders he is seeking is because they are necessary, because they're necessary at this time for the petitioner or the protection of the party's minor child. Petitioner remains hopeful that respondent will make good faith efforts to work on her personal issues so that she can someday be a healthy present in W's life without professional and or court supervision. Oh, thank you, Perfect Imperfect. Frozen? What was happening? Yeah, hopefully they'll go out and come back in. I don't mind. If it's lagging for you guys, go out and come back in. It's not for most people, but some people say there are. All good, all good, all good. Okay. I know mine's been kind of acting up today. Okay, perfect. Then I will keep on going, love. And I love that they put that in there because John has said that for literally since day one. John has legitimately said, I never asked, I didn't want to have full custody. And he doesn't say it in a negative way. He just says it because he doesn't want his child to only have one parent. Remember, he talks about all the time, I only had one parent. I only had my mom. I want my son to have both parents. And I hope that she can get it together so that we can have 50-50 custody. Right? But her actions that's not what's in the best interest of W. I'm very curious now to see what her evidence list is going to be. Okay, well, let me continue. Number 4, grant petitioner's request for order prohibiting third parties other than the minor child's biological family members from attending respondent supervised visits unless the parties mutually agree otherwise in writing in advance of the visit occurring. Subsection 1 of that. Petitioner is specifically concerned about respondent introducing significant others to the minor child. Given petitioner's habit of engaging in frequent but short-lived relationship with partners who are facing troubled legal issues. For example, respondent's boyfriend as of March 25, 25, custodial custodial incident was arrested the same day and was subsequently discussed in an attorney declaration filed by respondent's counsel for an improper chargeback of respondent's retainer fee. So they're talking about Itai here. Meanwhile, respondent's current boyfriend of a couple months, with whom she is allegedly already expecting a baby, was recently arrested for perpetrating DV against respondent in July of 2025. The court's July 24, 2025 orders precludes that the parties from bringing significant others to visitation exchanges, and petitioner requests that this order be maintained. Now, I don't know if you guys saw it, but there was a video out there. I don't know who put it together, and it showed all of the different guys that Baby W has been around. It was crazy. It was shocking. I think there was at least like 7. These are the new court docs that were just put in. You saw it, Chloe? It was 6? Okay. Yeah, there was one at Halloween. I mean, just every holiday there just happened to be a different one. It was crazy. Yeah, it was very sickening. But that is crazy. So March, she was with Pinky. She was with Itai in March. And in April, she's with Santos. Yep, started with Halloween. Yep, that's the same one that I saw. Okay. Number 5, petitioner is not seeking child support from respondent at this time. For all those people that were trying to eat 2K up, saying that he's just doing this for money, blah, 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 he's not requesting child support at this time. He could, and he should, but he's not. Number 6, petitioner requests that the court reserve on his ability to pursue prevailing parties' attorney fees in the event they prevail. Lost my spot again. Let me start over. Petitioner requests that the court reserve on his ability to pursue prevailing parties' attorney's fees in the event they prevails on his request for a permanent DVRO, as well as his ability to pursue attorney's fees and court costs as Family Code Section 271 sanctions against respondent in connection with the respondent's conduct in violation of court orders since the issuance of the October 31st, 24 stipulation in court case. So he's not going after her for child support, but potentially for attorney's fees. Number 3, procedural background and facts in support of petitioner's requested relief. The events that have transpired in this case, but particularly since October 31st of 2024, reflect petitioner's worst fear being realized. Indeed, when petitioner initiated this parentage proceedings on April 30th, 2024, he requested legal and physical custody of minor child because he already had concerns about respondent's ability to be a sober parent and put the interests of the minor child above her social, romantic, and business interest. Likewise, due to events that occurred between the parties following petitioner's initial efforts to end their romantic relationship and throughout respondent's pregnancy, petitioner also immediately sought a DVRO with the goal of protecting himself and his family from abuse, including online harassment by respondent. Petitioner's aforementioned prior request for a DVRO against respondent was dismissed without prejudice on October 31st, 24. Petitioner was hopeful that the parties' October 31st, 24 stipulation and order would provide a fresh start. He was led to believe that he and respondent had reached a genuine mutual agreement to put their past behind them, and that he was equally committed to having a healthy co-parenting relationship for the minor child's benefit. Instead, since their agreement was reached on October 31st, 24, respondent has completely disregarded nearly all of the terms that the parties spent extensive time negotiating, and she has also actively retaliated against petitioner for seeking relief from the court in connection with respondent's violation of the court orders. From the onset of these proceedings, respondent has engaged in unreasonable conduct that increases litigation costs and is contrary to the state of California's public policy to promote settlement. For the first 6 months of the minor child's life, no formal custody orders were in place, despite petitioner's repeated efforts through counsel to reach a stipulation for custody and visitation. Respondent refused to agree to any formal custody or visitation orders until October 31st, 24. Prior thereto, petitioner was at mercy of respondent with respect to being, next page, able to see the minor child, and respondent was adamant that petitioner only exercise visits in Los Angeles. At first, respondent denied petitioner visit with the minor child throughout the month of May of 24. Despite repeated requests through counsel to coordinate visits, in June 24, respondent was finally afforded a visit with the minor child on Father's Day weekend, but it was not without issue. We all remember that. Respondent failed to show for the first exchange, and unintentionally limited petitioner time with the minor child that weekend in violation of the parties' informal agreement. Fortunately for petitioner, as respondent's summer 2024 travel schedule picked up, she increasingly relied upon petitioner to take care of the minor child so she could travel and party with her friends. In fact, petitioner was the minor child's primary custodial parent in Los Angeles from July of 24 through October of 24, after which point the parties agreed that petitioner would have primary physical custody in Dallas, Texas, where he lives. Remember, that's when I was telling you guys that's how they came up with the 1 week, that John got 3 weeks and she got 1 week, because that's for that, what was that, 4 months? That's what it was. They were supposed to be 50-50. They're both supposed to have 2 weeks, but she always gave John an extra week so she could go party. In total, petitioner spent approximately $159,416 between April and November of 2024 to travel between Dallas and Los Angeles to exercise custodial time with the minor child. Petitioner aforementioned costs includes extended stays in Airbnbs, airfare, and other transportation costs and baby supplies, as well as petitioner's cost to transport the minor child to and from Los Angeles in November 24 for respondent's first visit pursuant to the October 31st, 24 stipulation and order. These costs are separate from petitioner's attorney fees and costs incurring in trying to enforce court orders, protect the minor child, and preserve his own right to be free from abuse. Those costs are extensive as well, and as such, petitioner asked the court to reserve his ability to pursue prevailing party fees and sanctions against respondent. Crucially, respondent began violating the October 31st, 24 stipulation order immediately after it was issued. The October 31st, 24 stipulation order stated the respondent's visits were to occur in Los Angeles, and petitioner was to provide transportation between the minor child's residence in Dallas and respondent's parenting time in Los Angeles. Accordingly, petitioner flew with the minor child to Los Angeles at the end of November to drop him off for the respondent's 1 week period of visitation. Without telling petitioner, respondent proceeded to take the minor child. Wait a minute, I didn't know it was literally her first month of that visit that she took him to Texas. The first visit? That's crazy. I don't know why I thought it was like a couple months, but yeah, that makes sense because it was Thanksgiving. Sorry, it just hit me. I was giving her credit. I thought it was like at least a few months. Okay. Let me back up and start again. My apologies. The October 31st, 24 stipulation and order stated that respondent's visit were to occur in Los Angeles, and petitioner was to provide transportation between the minor child's residence in Dallas and the respondent's parenting time in Los Angeles. Accordingly, petitioner flew with the minor child to Los Angeles at the end of November 2024 to drop him off for respondent's 1 week period of visitation. Without telling petitioner, respondent proceeded to take the minor child from LA to Corpus Christi, Texas. Hold on, I gotta flip page. Respondent then flew with the minor child from Corpus Christi back to Los Angeles, where petitioner was waiting to pick him up to bring him back to Texas. Due to respondent's conduct, the minor child was forced to take 4 flights unnecessarily. Petitioner only discovered that respondent had exercised her November 24 visit in Texas through social media. Respondent concealed the minor child's whereabouts from petitioner and jeopardizing his health by forcing him to participate in excessive travel. At no point did respondent bother to ask petitioner if she could exercise her November 24 visit in Corpus Christi. Had she asked to spend the visit in Texas, petitioner would have agreed, and he could have spared the minor child the hassle of taking 4 flights in 1 week, while also saving his own time and money on round-trip tickets to LA, or flights to LA. Following the November 24 visit, the minor child, I'm not going to read, I will never read what a child, any of the medical stuff, so I'm not going to read that. The child got sick, is all I'm going to say. Let's see. Fortunately, respondent agreed to exercise her December 24 visit in Dallas, Texas, as the minor child was still, or he was recovering With regards to respondents' next two visitation weeks awarded under the October 31st stipulation order, occurring in January and February of 25. Respondent exercised one such visit in Dallas by mutual agreement, and she failed to show up for the other visit. Why do I not remember that? Don't you guys please don't put in the chat what he had. We do not talk about that over here. The child has a right to his privacy. That information should have never been put out. Bree chose to put out what the child was diagnosed with. That won't be put out over here. Okay, so that's the warning. We don't talk about it here. You will get blocked, okay? Yeah, absolutely. There's no reason for that. Now that I've mentioned it, actually, if one of the mods could put a note up or pin a comment, and then if you see it again, then they can get blocked because we won't talk about it over here. Okay. Okay. Respondent exercised one such visit in Dallas by mutual agreement, and she failed to show up for the other visit. On March 17, 2025, the court made orders requiring respondent to exercise her visits with minor child in the state of Texas. Respondent did not appear for the March 17th hearing, although respondent has acknowledged on multiple public forums that she was aware of the hearing and simply chose not to attend. Respondent was immediately provided with a copy of the March 17th, 2025 order requiring her visits to be exercised in the state of Texas. In advance of respondent's March 25 visit, respondent read the court's March 17, 2025 order along with petitioner's counsel email regarding said orders while on live stream on social media. We all watched that. Despite respondent's acknowledgement of the requirement that she exercise visits in Texas, respondent chose to remove the minor child from the state of Texas immediately upon picking him up from petitioner's custody in March 25. Respondent took the minor child to Los Angeles without telling the petitioner, in violation of the March 17, 2025 order, and attempted to conceal his whereabouts thereafter. Once again, petitioner only discovered the minor child's actual whereabouts through social media. After petitioner discovered the minor child was in Los Angeles, but prior to respondent returning the minor child to petitioner's custody, respondent was frequently observed live streaming and posting about her actions on social media, including but not limited to making comments about kidnapping the minor child and leaving him with P3DOs. Petitioner obtained ex parte orders for the minor child's return on March 24th of 25, and the exchange was scheduled to occur on March 25th, 25 at 12 p.m. at the Central Los Angeles Police Department. Respondents' visits were ordered to be professionally monitored in Dallas County, Texas thereafter. Respondent failed to return the minor child to petitioner at 12 p.m. on March 25th. She did not show up at all to the police department and proceeded to withhold the minor child for hours inside the content creator house where she resided at the time, necessitating police involvement to secure the minor child's release to petitioner's custody. Respondent live streamed the entire confrontation with the police while the minor child was present inside the house and also depicted on live stream. When the minor child was finally released to petitioner, respondent taunted petitioner in person and then sent her friends to follow petitioner and his family in their car. Respondent's then boyfriend was then arrested. Upon release from jail, respondent and her then boyfriend joked on social media about taking the minor child again. Concurrently to the aforementioned custody and visitation issues, respondent's abuse of petitioner had also intensified by March 25. Petitioner filed a second request for DVRO on March 27th, which the court granted in part. Specifically, the court ordered respondent not to abuse petitioner. Respondent had basically ignored the existing DVTRO. Confusingly, when respondent's visitation of the DVTRO, such as the Domestic Violence Temporary Restraining Order, have been brought to respondent's counsel attention, she has suggested that the DVTRO issued March 27, 25 is not a normal restraining order because the courts only issued orders not to abuse. Respondent appears to believe she is free to continue threatening, harassing, stalking, and disturbing petitioner's peace on social media because such conduct cannot constitute abuse. Petitioner's second brief RE First Amendment issue set forth various legal authority which, hold on, I gotta flip pages, with support otherwise. Respondent is not absolved from wrongdoing simply because her abusive conduct is occurring via a public social media account, as opposed to in-person conduct or by sending communication to petitioner directly. Moreover, the parties specifically agreed, pursuant to the October 31st stipulation and order, to impose restraints on the ability to engage in certain speech on their respective social media platforms. Thus, respondent is not only engaging in conduct that in itself is abusive, but her actions also violate the October 31st, 24 stipulation and order. I'm moving, love. I'm moving. This malicious nature of respondent's conduct is further highlighted by the fact that when petitioner has sought and obtained relief from the court, respondent has intensified rather than recidified the behavior that led petitioner to seek relief in the first place. It is anticipated that respondent will claim petitioner has also spoken negatively about her on his social media platform, and as a result, petitioner cannot complain that about respondent's behavior. Importantly, the only party who has repeatedly requested that the other party's conduct stop is the petitioner. Thank you guys so much for the gifts and the daily heart means. I appreciate you guys. And the taps. Oh my gosh, you guys, 228 taps or likes or whatever they're called. You guys are amazing. You guys, it hurts to walk. If I just kind of stand and keep moving, I do a little better. So it's better for me like this. But thank you guys. I love that you guys are so. There's my man. He loves me. I love him. He's a loyal one, that guy. Okay. And not only that, I have to say this on here, right? No, it's true. I would not lie to you. Steph, I would not. I'm terrified of you. Thank you so much, Miss Raina. Thank you, love. Every gift to me, I absolutely love. But anytime somebody comes in and gives their very first gift to me, it just melts my heart. Thank you. Welcome to the stocking. But not only, she's never said anything positive about 2K on her platform ever. 2K continually goes to bat for her, and cusses people out for, being disrespectful to her. So I think it's just crazy that that's even a thing. But nonetheless, let me continue. Where was it? Okay, the only party who is currently restrained by a temporary DVRO is the respondent. While there have been occasions after extended periods of ongoing online harassment by a respondent in which the petitioner has finally attempted to defend himself, the evidence will show that petitioner's limited commentary about respondent is mild in comparison to respondent's conduct and largely in self-defense. Without question, respondent's insistent harassment has destroyed petitioner's mental and emotional calm to the point that petitioner has at times felt compelled to communicate a public response. However, there is a stark difference between petitioner's behavior and respondent's behavior, and only respondent's behavior rises to a level of continued abuse. Amen to that. Respondent has unfortunately engaged in public smear campaigns about petitioner, making false accusation after false accusation about him without regard for the impact it has on petitioner's mental state or reputation. At this time, respondent also appears to be utilizing her recent court filings to advance a separate but equally false narrative that petitioner is unreasonably controlling, vindictive, and set on keeping respondent away from the minor child at any cost. Thank you, Mama. Respondent has been making a spectacle of the judicial system, presumably to distract from the actual issues that are before the court. Respondent has gone so far as to alert social media in advance of the upcoming court hearings, thereby putting the general public on notice that new documents will be available soon and ready for download. Those documents are subsequently, I can never say that word, I can't read, disseminated across social media by users who purchased them from the court website, with other users commenting and rallying behind each party. To be clear, this discussion and or publicizing of court documents in detail is not among the abusive conduct at issue in petitioner's DVRO, although it has certainly exacerbated tensions between the parties. It is the respondent's violations of the court orders and nothing else that cause respondents' visits to be professionally supervised. Meanwhile, it is respondents' obsession with utilizing her social media presence to discuss, threaten, disparage, mock, and harass petitioner and his mother, which has left petitioner with no choice but to ask the court to intervene by issuing permanent DVRO against the respondent to help restore petitioner's peace and put a stop to respondent's abusive behavior. Amen to that, and cheers. Absolutely not. He's definitely not wrong in that. She, not only does she say when the things come out, and again, people probably check on their own. I have absolutely no idea, but the worst part is she tells them when and where the court's going to be and encourages people to show up. Now, I don't know if anyone has ever actually showed up at one of the trials. And again, court is a public place so people can go. But encouraging people to go is crazy work. Okay, number 4, legal authority. The legal authority which allows the court to issue the restraining orders requested by petitioner are set forth in the 2 prior briefs. RE First Amendment issues filed by petitioner in the case. In the event the court grants petitioner's request for permanent DVRO, the presumptions against an award of sole or joint custody to respondent set forth in Family Code Section 3044 will apply. At this junction, respondent has not done anything to be able to rebuke the Family Code Section 3044 presumptions. Afterwards, let's look that up and see. I thought when it involves a minor, you can't go. No, you can. Now I don't know for this one if they may close them, but yeah, you can go to custody courts. Shouldn't be, but you can. They're open. As mentioned here and above, respondent has failed to comply with the March 27, 2025 DVTRO. The number of violations are extensive, including one occasion where respondent's boyfriend, while live on social media, went in person to a hotel where petitioner was. Sorry, I hear my grandbabies playing. That's why I'm laughing. Not at the court records. I don't want anyone to think that. I can hear two of my other granddaughters over playing with the babies. That's what I'm hearing. Okay, sorry. I love the. What the hell just happened? Oh my god. My fat fingers, hold on. I backed out. Hold on, I gotta make sure I'm in the right spot. Can't remember what page I was on. It's this one or this one. Oh no, I was past this. Hold on. Sorry, guys. Right here. Oh no. Okay, hold on. Sorry, guys. I have to find my spot again. Where I was. Well, I can't remember. Oh, I think I was right here. Hold on. Let me go back and read this last part. Oh no, I was past that. Sorry, guys. I'm just going to start from here. Some of this we may be reading again. I apologize. I backed out. Okay. Petitioner obtained an ex parte order for the minor child's return. Oh, yeah, we did read this. Concurrently, respondent. Oh, I think this is where I was. Okay, I'm going to just read from here. Concurrently to the affirmation, custody, and visitation orders, respondent's abuse of petitioner had also intensified by March 25. Petitioner filed a second request for DVRO March 27, 2025, which the court granted it. Oh, I did read this. Hold on. Sorry, guys. Okay. All right, found it. I'm going to read this last sentence or paragraph and then move forward. Okay, respondent has unfortunately engaged in public smear campaign against petitioner, because we haven't read that yet. In anticipation, respondent will claim. Okay, here we go. Okay, respondent has unfortunately engaged in a public smear campaign against petitioner, making false accusation after false accusation about him without regard of the impact it has on petitioner's mental state or reputation. At the same time, respondent also appears to utilize her recent court filing in advance filings to advance a separate but equally false narrative. The petitioner is reasonably controlling, vindictive, and set on keeping the respondent away from the minor child at any cost. Respondent has been making a spectacle of the judicial process, presumably to distract from the actual issues of the that are before the court. Respondent has gone so far as to alert. I think this is where we were. There we go. Alert there's a thing over that. Violation, I think it's of the DVTRO abuse itself. Even a merely technical violation, which respondents' violations are not, supports the issuance of a permanent restraining order. In addition to violating the DVTRO, respondent has not exercised all professionally monitored visitation time awarded to her. And she has failed to consistently follow the monitor's rules. Despite asking for the ability to exercise 6 to 10 hours a day of the supervised visitation time, and extensively complaining that petitioner was intentionally interfering with the ability to exercise that duration of time with the minor child, respondent has largely exercised only about 2 hours per day. Thank you, guys. I'm gonna read that again. So, despite asking for the ability to exercise 6 to 10 hours a day, which the judge greatly encouraged, right? Let's not forget that, of supervised visitation time, and extensively complaining about petitioners was intentionally interfering with her ability to exercise that duration of time with the minor child, respondent has largely exercised only about 2 hours per day since her visitation was ordered to be professionally monitored visits. And some months, respondent has also failed to exercise a full week of her visitation days. Respondent may claim that her failure to utilize all visitation time is due to the cost of monitor visits. However, respondent has notably continued to flaunt her wealth on social media during the same time, making various designer purchases and afford luxury travel, including taking 2 vacations to Hawaii with her boyfriend since May of 25. Furthermore, respondent struggles to adhere to rules. Respondent has asked petitioner to agree to deviate in some capacity from the monitor's rules almost every visitation period. She has been late with respect to booking and scheduling, and she previously attempted to schedule visits outside of Dallas County, where visits are ordered to occur. And she asked respondent to allow third parties to be present for those visits. There have also been occasions where she brought her significant other to a visitation exchange and created an issue, resulting in the court making an order on July 24th, 2025, precluding significant others from being present at exchanges. Respondent has also recorded and or photographed aspects of her visit, despite such conduct being prohibited by the monitor's rules, absent an agreement between the parties allowing otherwise, when no such agreement exists. Oh, she absolutely did, Nikki. In the unlikely event the court declines to issue permanent DVRO or otherwise making findings that respondent has perpetrated abuse necessary to trigger the Family Code Section 3044, presumptions analyze of the best interest of the minor child also support the award of sole legal custody and sole physical custody to petitioner and supervised visits to respondent in Dallas County. Petitioner's memorandum of point and authorities filed on April 18th, 2025, analyze the applicable La Musca factors that the court is required to consider in making a determination on a parent's move-away order request. Moreover, petitioner is the only party who has demonstrated the ability to prioritize the minor's health, safety, and welfare which factors are relevant to the court's determination of the best interest of the minor child under Family Code Section 3011 and Family Code Section 3020. Although respondent made a fuss about her desire to attend W's medical appointments in person, including during the May 2nd, 25 hearing in this matter, respondent has failed to attend a single appointment. Respondent also lacks the stability and support in Los Angeles. Respondent has moved residence no less than 4 times since W's birth in April 2024, and she has recently talked about moving again with her current boyfriend into a new residence. Respondent's friend group is apparently rife with other drug and alcohol users and individuals facing various legal issues. Respondent appears to be more concerned with presenting as a present parent on social media and utilizing the minor child for attention on social media rather than actually spending time bonding with the minor child one-on-one. This is demonstrated by her repeated request to record and or photograph visits rather than just spend time with the minor child. Moreover, although petitioner communicates updates about the minor child's development on Our Family Wizard, respondent has made parenting decisions during her monitor visits that ignore and or disregard those updates. For example, with respect of the minor child's diet. Conversely, petitioner has been responsible physical and financially for 100% of the minor child's care since October 31st of 2024, when he was awarded primary custody in Dallas, Texas, pursuant to the parties' stipulation. Prior to that, he was the primary custodial parent in Los Angeles, California between July and October of 2024, meaning she only had the very end of April, so that's a couple days that he was there, May and June. The minor child is closely bonded with petitioner's mother, with whom they live, as well as petitioner's sister and other family members in Texas. The minor child is a part of the community in Dallas, Texas, and is thriving. As set forth in the Family Code Section 3020, the minor child has the right to be safe and free from abuse. As recently as July 25, respondent's current boyfriend was arrested for perpetrating domestic violence against respondent. Respondent and her current boyfriend live together. Respondent has also engaged in numerous physical altercations herself with former friends, significant others, and even apparent strangers, with which have been recorded and shared across social media. Respondent's social media content depicts respondents publicly abusing alcohol, including by sharing extensive content where she is visibly intoxicated, which also occurred early in the minor child's life while respondent was responsible for the child's care. We showed those videos over here. And regularly discusses the use of other substances such as Molly, the cocaine, although it is anticipated the respondent will claim those remarks were all just and just. We often just, say that just, joking. Petitioner has seen social media posts where respondent and her friends appear to be preparing and or sniffing lines of de cocaine, so I guess it will come up. Respondent has also openly provided alcohol to minors, including her current boyfriend, when he was 19 years old. Respondent's boyfriend is now only 20, and respondent presumably continues to furnish alcohol for him. As she claimed, he was heavily intoxicated when he was arrested for the DV charges. in Catalina Island in July of 2025. Oh, that's right, Missy. It doesn't count if it was Coachella. Forgot. Okay, you guys are funny. Accordingly, among the reasons petitioner is seeking orders awarding him legal and physical custody of the minor child is, in fact, that respondent's lifestyle is simply not conductive to raising a child in a healthy environment. In addition, petitioner refers the court to the violation of court order on respondent's part and the abusive behaviors perpetrated by respondent and recently her live-in boyfriend as respondent's direction as discussed herein above. If granted, the order requested by petitioner will still afford respondent frequent and continued contact with the minor child as intended by Family Code Section 3020, but in a manner that prioritizes and protects his health, safety, and welfare. In conclusion, petitioner respectfully requests that the court grant him his request relief at this time of trial. I feel like I did miss a page though, or at least a section, because we were talking about Santos, and then I got to hearing my grandbabies giggle, and I got excited and I pushed the button. So let me see if I can find that. Okay, I did. I thought so. Okay, that's okay. I'm gonna find it. Just give me a second. Yeah, Santos at the hotel. That's what I thought. Okay. Let me find it. Sorry, guys. You hear the little girls giggling. I just can't help it. And that one's crying. You guys are almost at 400,000 taps. You guys are amazing. Yeah, just talk amongst yourself. You'll be good. Okay. Legal authority. So it must be the page before this. No. Okay. Anyways, because the first engaged in a public smear campaign, so it has to be this page. 1, 2, 3, 4, 5, 6, 8, 9, 10. It is responsibility. And then we have another thing. We have the witness list coming up too. So there's still more court documents. Oh, thank you. Legal authority, section 4, paragraph 2. Oh, that's exactly where I am. Look at you. Thank you, love. Okay. As mentioned herein above, respondent has failed to comply with the March 27, 2025 DVTRO. The number of violations are extensive, including one occasion where a respondent's boyfriend, while live on social media, went in person to a hotel where petitioner was staying and searched for him while threatening to physically hurt him. Respondent's boyfriend also recently threatened, also via social media, one of petitioner's witness who testified about respondent's physical aggression during the September 24 hearing of petitioner's prior DVRO request. The aforementioned incidents were precipitated by social media content of the respondent, including where she and her boyfriend are harassing and or threatening petitioner. Okay, a violation of the time of the DVRO issue in itself. even a merely technical violation, which respondents' violations are not, supports the issuance of the permanent restraining order. So I read the rest of that. Okay. The next one is the witness list, but let's chat about that for a little bit. What are your guys' thoughts? What do you guys think? Santos will also be named, I hope, as a witness. I would think so. I don't know. That's where coming up next. Sandy Toes, ouch, was picking out 4 suits today for court. It made me laugh. That is crazy. I mean, that's just the biggest mistake for her to have him there. Enzo's Carrot, their trial is next. It starts August 22nd. It's the 22nd, 25th, 26th, and 27th. Then we will go over those court docs on what it is. They will determine at that point the move away order, who has full custody, sole custody, physical custody, the whole 9. What visitation will be like? Will she continue to have supervised visits? If so, how long? All of that stuff. I will go over all of those court docs, answer any questions you may have, and then I'm done. Right? I'm not following along to go to the next, with the next baby or whatever is going on. I think all 2K's friends will be there. Mom said he was going to get a suit too. Good. Okay. 2K's lawyer is full of shit. She's selling him a dream. Well, that's interesting. I don't know what dream she's selling him, because he's been living in a damn nightmare having to deal with that woman. And the last person on earth that baby needs to be with is Bree. I have not heard back from AA, so I don't know. I really hope so. I really, really hope so. I absolutely adore her. Wait, what did I miss? What's going on? We were just reading 2K's court docs. 2K's lawyer is absolutely amazing. But Bree's people truly feel that Bree just, she does no wrong. The difference is that 2K supporters can admit when, what things have been done wrong, that 2K has done wrong, whatever. We're not thinking that he's just, he's not perfect. Nobody's perfect. But he has done a damn good job controlling himself, biting his tongue through all of the shit that comes out. And then he finally makes somewhat of a statement, and all of a sudden people are like, oh, he's just this terrible guy. That's absolutely crazy. But everything she's done this whole time, let's not forget, we can go all the way back to when baby W was, 3-4 weeks old, and she was so inebriated she couldn't take care of the baby. Yeah. And he did. He grew as a person. People want to talk about, but when she found out she was pregnant, he said, are you going to get an AB? And he was kind of for that. I think those are somewhat, it could be on 2K. Stop it. I think that's a normal conversation, especially when somebody gets pregnant and they're no longer together. That doesn't mean that he doesn't want to be a father. That's a conversation. And he said that he's grown greatly from that. He has. Nobody can say anything negative about him in regards to him being a dad. Well, because he stays with his mom, or they live together, and she takes care of him while he works. It's equivalent to what I do. I live on my daughter's property. I take care of the baby while they're at work. I don't raise their child. I take care of them while they go and they make a living. What are you guys talking about? Okay. And she is an amazing grandmother. I don't support anyone, period. So don't get it twisted. Yo, think 2K is a saint. Is unreal. Thinking 2K. Who said he was a saint? I didn't say that. Sometimes I think people just take the things that I say and twist it to fit their narrative. I literally just said the difference between people who support 2K is we don't think that he's perfect. We announce when things that he's done has not been the best or whatever. Bree's followers cannot do that. They think he's perfect. In regards to this situation, he absolutely positively is the best parent. He is a phenomenal parent. a phenomenal parent. We're not there with him 24/7, so we don't know. But what we see and what we hear, and to see how W is growing and excelling, that has nothing to do with his mom. Nothing. That has to do all with his dad. 2K has been the one fully supporting said child. She did 2 months. That's it. So, okay, let's go over the witness list, and then I'll do a quick recap, and then I will probably refilm this and then post it up on my team. All right, so this is the witness list to the court and respond to. Oh, I don't need to read all that. Okay. Submit the following list of witnesses he intends to call upon to testify at the time of trial in the above captioned matter, the date of which has not been set. Oh, no, it has been. Yes, love. Before I move on, what you got, CB? Can you imagine me doing a cart right now? Shit, I can barely move. My back is jacked. Yeah, I'll look that up when we're done with this one. How is Bree going to have her mom move in and Nanny and I, like, when is the mother's... Right. I said the same thing, too. I'm like, how is it that you complain about John having his mom take care of W, but yet you're going to have a nanny and your mom move in? When is it that you... When are you going to take care of the baby? Yeah, I have an ice pack. I'll put it on here when we're done. Okay, so let me move along with the witness list so I can go ice my back. Obviously, number 1 is John. Number 2 is Bree. Number 3 is Mama 2K. Wait, hold on. Oh, it says, okay, so it says John, petitioner, anticipated testimony will encompass all pending issues. Time estimate 3 hours. Number 2, Bree, respondent, anticipated testimony will encompass all pending issues. Estimated time 3 hours. Mama 2K, anticipated testimony will encompass the DV and visitation issues 1 hour. Petitioner reserves the right to amend, supplement, or augment this witness list to call or not call any witnesses designated herein, or to call any such witness in an order consistent or inconsistent herewithin, and to call any rebuttal and or impeachment witnesses as necessary in the interest of fairness and justice. So it's just him, Bree, and Mama 2K. And I think that's all it really should be. It doesn't need to be anybody else because no one else is a part of it, you know. Oh, here we go. 3020 verified pleadings by petitioner under oath. Oh. The other one was 3044. What is that one? It's 3044. Kelly, can you look that one up? The 3044. Yeah, I think at a certain time you have to. I need to go get an X-ray done to see if I broke it when I fell. Why isn't the visitation center testifying? Well, they may. You know, this is just John's side. But in order for the visitation center to testify, that would mean every single person. Every time that there's a visitation, it's not the same monitor. Right? So they'd have to call everyone. That's why they do such detailed visitation lists. And I believe most of them also do, like, you know, we went over the visitation list, right, where it's every few minutes. Then there's typically also, like, a summary. So for trial, the visitation center has probably written up a full detailed report. Broke your booty bone doing. I fell a couple months ago. Remember when I fell off the stairs? Here it is. Hold on. 3044. Rebuttal against awarding custody to a parent with history of DV. Oh, okay. Yeah. Crackers and bottles. I still have flashbacks, literally. I was surprised actually. Maybe it'll get brought up that during all the visitation, especially the 4 hour, maybe not as much the 2 hour ones, no meal needed, but the 4 hours from 11 to, what was it, 11 to 2? Wait, 11, 12, 1, 2, no, 11 to 3 and no food. That's crazy. Bree's lawyer said has not submitted yet. It'll probably come quickly behind since trial's next Friday. So as soon as that comes in and I get it, I will go over that one as well. So it is a lot, but I think that was written up. Hey, Beth Love. I think that was written up very well. And a fraction. And it took 6 months to get better. Oh my god. And don't to sit. Yeah, just the sitting thing altogether is just very painful. I doubt there will be. Yeah, I don't know who she would call as a witness. Angie, you need a tailbone relief pillow. Check Amazon. Okay. Thank you, Amy. I will do that. Yeah. Oh, I tried that, sleeping on my side. Oh my god, that is so painful. I thought sleeping on my stomach was going to be better. It's not. It's not. There's just, yeah. What were the new docs about? So the new docs, for those of you coming in, I can do kind of like a quick. Thank you, Mama. I'll always give you the names of them. Okay, so we went over the exhibit list, which was extremely interesting. So we did the exhibit list. And then we did the witness list and the, what was this one called? Trial brief. The trial brief. Well, howdy, cowboy. Thank you, Angel. Another first gift. Thank you, love. Oh my gosh, Miss Rita, thank you so much. Oh, shoosh, I missed that one. There is no position. Trying to pillow. Yeah, I do have. I'll bring my pregnancy pillow up today because I have stairs at my house. I love you guys too. You guys, that every gift means the world to me because you guys never ever have to gift. But whenever I get those first time gifters, oh my gosh, it means so much to me. Yeah, I can't do the stairs, and so I'll have my grandson go grab mine. Knees up, and no, I am straight. And the doesn't she had until 12. Wait, what? Oh, I missed Mackenzie's thing. Wait, hold on. Pin the doesn't she had until 12 comment. I don't know what you mean, love. Can you ask that again? Will you post the docs anywhere for us to see? I've never done that before. How would I post them? Oh, you mean like as pictures on TikTok? I could probably do that. Lisa, thank you, love. I could probably do that. Oh, I don't do Discord. I don't do Reddit. Listen, guys, I barely know how to work TikTok, okay? She has until midnight midnight tonight to submit it. So I may be back. Wait, so if it comes in, do you guys want me to go live again tonight or wait till tomorrow? Would you guys want me to do the exhibit list again? The exhibit list, even though it's long, it doesn't take long because it's just items. Do you want me to read the exhibit list again? Oh, her attorney will get it in. Go live tonight. Yes, please reread it. Tonight if it comes in. Okay, I'll do that. If it comes in and it's sent to me, because remember, I don't go get them. I get Bree's attorney has until tonight to get hers in. Yes, I will post over on YT. I was thinking about re-recording it so you guys miss all this other stuff, but I'll probably just do it. Midnight Cali time, which is 3 a.m. for me. Yeah, so that's... Thank you, Ellie. You guys are so sweet. Try rolling a comforter. Okay, Steph. I'll try that. Thank you, Lisa. I love you too, girl. Okay, so let me go over the witness list. The exhibit list. Sorry guys, this pain makes my mind not really think right. No way. You guys, 500,000 taps. You guys are amazing. Thank you guys so much. Can you put Breeze docs up too? I'll be in bed. Yeah, absolutely. Yeah, if I get them and I go live again, then I will absolutely put them up. I have several that I need to put up over there. I have to re-record them because for some reason they're paused on TikTok. I don't know why. I probably did something wrong. I'm sure of it. I'm just not tech savvy, but I got Steph. She helps me. Okay, let's do this, the exhibit list. It's very interesting. Okay, here we go. I'm not going to read the dates, so this time, gotta have my Diet Coke. My white tea is the same as this channel. There's also a link in my bio. Well, I'm working on that. Thank you, Daisy. Okay, here we go. Number 1, petitioner's request for DVRO filed May 3rd, 24. Petitioner's reply declaration filed September 10th. Stipulation and order filed October 31st of 24. October 31st, hearing transcript. October 30th, hearing transcript. September 17th, hearing transcript. Number 7, notice declaration filed in support of petitioner's ex parte request for order of January 15th, 25. Petitioner's ex parte request for order filed January 15th. Petitioner's request for order or entry of Nunc Pro Tunc. No clue what that is. Order filed January 16th, 25. March 17th, 25, minute order. Substitution of attorney filed December 3rd, 24. That's Breeze. 12, proof of electronic service. RE petitioner's RFO filed January 16th. 13, petitioner's declaration. No ex parte notice given filed March 24th. 14, petitioner's ex parte request for order filed March 24th. Number 15, ex parte order issued March 24th. Petitioner's request for DVRO filed March 27th. 17, petitioner's exhibits filed March 27th in support of request for DVRO. Number 18, temporary DVRO issued March 27th. Petitioner's supplemental declaration filed April 2nd. February 19th, emails exchanged between respondent. March 18th, 19th, 21st, and 22nd is emails between respondent. Number 25, this is where it gets good. This is the stuff we know. Oh, she submitted? Okay. Well, I don't say who sends them to me, but if you send them to me, right, if you guys can send them to me right now, I'll go over them right now. Okay. Again, when you guys send me stuff, I never ever say who sent it to me unless you want me to. Besides that, anytime you send me anything, it's between us. Okay. Number 25, TikTok of respondent's boyfriend threatening petitioner. 26, TikTok of respondent threatening petitioner's family. 27, TikTok of respondent discussing missed court appearance 317. 28, TikTok of respondent in a physical fight. I wonder if that was the one at the, okay. Thank you, love. I wonder if that was at the, remember when she was at the, that restaurant or whatever, and she got in that fight with that lady, and she hit her with something? I wonder if that's what it was. Okay. Where was I at? Oh, physical. Okay. Number 29, TikTok of respondent in a verbal altercation. 30, social media video of respondent's verbal abuse of petitioner. 31, TikTok of respondent's verbal abuse of petitioner threatening his mother. 32, video of respondent's appearance on the Single Mom Attorney podcast. 33, social media account created in name of respondent's derogatory nickname for petitioner. 34, TikTok of respondent threatening to F up petitioner and petitioner's mother. 35, TikTok of respondent calling petitioner to gay. 36, TikTok of respondent mocking petitioner. 37, TikTok of respondent making harassing statements about petitioner. 38, another TikTok of her calling him too gay again. 39, TikTok respondent making harassing statements about petitioner. 40, TikTok of respondent discussing intimate relations with the petitioner. 41, TikTok of respondent making false statements about the petitioner's home, calling it a trap house. 42, TikTok of respondent admitting to posting with the intention of upsetting petitioner. 43, social media post of respondent discussing kidnapping her kid, beating up petitioner and his mother. 44, TikTok of respondent stating petitioner likes men. 45, TikTok of respondent stating petitioner is gay and discussing intimate pictures. 46, TikTok of respondent threatening to kidnap her kid. 47, Snapchat images, respondent admitting to posting content to stir shit up. Snapchat images, respondent calling petitioner a shitty baby daddy. 49, TikTok of respondent addressing petitioner's counsel. 50, Snapchat image respondent making harassing statement about petitioner. 51, Snapchat image respondent calling petitioner's residence a trap house. 52, social media messages, respondent sharing petitioner's intimate photo. That's one right there that could be an issue. If she actually shared an intimate photo, that could potentially be revenge, something along the line. I don't know. Absolutely. Yeah, keep it cuter, keep it moving. Okay. Okay. Where was it that I just saw that? Oh, there you go. Okay. Number 53, TikTok of respondent stating petitioner likes to grape girls. Another one that could be an issue for her. 54, TikTok of respondent talking about bringing W back to LA and kidnapping him again. 55, respondent talking about W coming back to LA soon. 56, social media recordings of respondent threatening to F you up and burn your motherfucking city down. 57, TikTok of respondent and W in LA March 24th. 58, TikTok of respondent and W in LA stating she hopes petitioner's attorney gets in a car crash. 59, TikTok of respondent showing the 317 minute order. 60, TikTok of respondent reading the email from petitioner's counsel RE 317 minute order. 61, TikTok of respondent reading the 317 minute order. Now, mind you, that lets us know, that's going to let the court know that she knew that she absolutely positively could not take W out of Dallas. I don't necessarily know that that's going to make a difference because, again, she wasn't served correctly. You know what I'm saying? Like, she still needed to be served the right way, and she wasn't, but nonetheless, we will see. It's still going to let her know she does not make good decisions on her end. 62, TikTok of pole dancing in respondent's residence while W with respondent in LA in violation of court order. 63, video showing respondents kick post labeled as leaving W with P3DOs. There's just no online persona. This, amen. Absolutely. Exactly how it should be put too. Oh, hold on. Now I don't remember that, but again, I don't watch Kick, but that's crazy when if you kidnap your child, and then you title your live leaving W with P3DOs. That's crazy. Like, how is that even a joke? How is that, however she's gonna try to twist that, how is that funny? How is there anything entertaining or whatever about that? That's mind-boggling to me. Okay, let me finish this up here. 64 respondents kick live stream on March 25th, 2025. 65 recording of respondent threatening to steal W again. 66 recordings of respondent threatening to kidnap W from supervised visits in Dallas. What? Wait, who's in here? Something on Kick saying Angie is talking. I don't know what you mean, Mama T. I have no idea what's happening. Okay. I'm just going to keep reading because I don't know what's happening. Recording of respondent threatening to kidnap W from the supervised visits in Dallas. Number 67. Recording of respondent refusing to return W, threatening to kidnap him again. 68. TikTok of respondent calling petitioner a broke baby daddy. Threats to go on kidnapping spree, among other harassing statements and verbal abuse. 69. TikTok of respondent mentioning a plan to get W back, then boyfriend's released from jail following events on 3/25. TikTok of respondent threatening petitioner's mother, calling him gay ass bitch, among other harassment and verbal abuse. 71. TikTok of respondent discussing the March 27th DVRO. 72. TikTok of respondent calling petitioner a bitch after attempted service of the DVRO. That's when they were trying to serve her, and she kept ducking them, but she was recording the whole thing, and then she went on camera. She's like, "Yeah, you dumb bitch," or whatever. 73. A respondent admitting to trolling John. 74. TikTok of respondent's boyfriend showing up to petitioner's hotel, threatening to fight him in June of 25. 75. TikTok of respondent and respondent's boyfriend threatening to fight petitioner. 76. TikTok of respondent playing subpoenaed police footage. 77. TikTok of respondents referencing police reports for DV incident with current boyfriend. 78. Snapchat story respondent's boyfriend harassing petitioner. And that was in August of 25. Next page. Um, 78. Recording of respondent and her boyfriend discussing violation of March 17, 25 order harassing petitioner, August 25. Number 80. TikTok of respondent's boyfriend threatening petitioner's witness in July of 25. 81. March 2025 TikTok of respondent's boyfriend with W. Number 82. TikTok's respondent sharing inspiration for her bikini line. 83. TikTok's respondent's boyfriend taunting petitioner's sister. 84. Excel spreadsheet of petitioner's expenses incurred in connection with either party's parenting time in California from April of 24 to November of 24. 85. Complete record of our Family Wizard messages exchanged between petitioner and respondent. 86. All professionally monitored visitation reports for respondent supervised visits with minor child. And 87. Various photographs depicting petitioner's custodial time with the minor child and the minor child's lifestyle with petitioner. Petitioner reserves the right to amend his exhibit list through the time of trial and to offer any and all rebuttal and or impeachment exhibits as necessary or appropriate. So that is his exhibit list. His witness list is only John, Bree, and Mama 2K. If there's any issues in the chat, feel free to exit stage left. I don't know if she still has a kick, and even if she did, I probably wouldn't put it on here. So yeah, amazing exhibit list. She made it. She really did flower power. I said it from the very beginning. She is making this very easy for John. I'm curious to see what exhibits her attorney's gonna have. I'm done. I missed a lot. We'll be able to. Will I be able to rewatch this? Yeah, I will post it on. White Tea. I think maybe what I'll do too is I'll try to break it down into videos here. I'll just do 10 minutes and just try to read through the stuff with no interruptions, like no comments. So I guess the no jumper one is in there. It's just not coded as no jumper. Someone else said it was a certain thing. I think it was timing of when it was, but I don't know. Yeah, you should at least two since then. Yeah, I think it's going to be a pretty easy case. I absolutely agree to that. It is in there. Yeah. It's just not named. No, Bree's side is not out. Okay, thank you, Sammy. No wonder why she stopped. Well, see, that's exactly what I think was that Summer that said that. I asked that earlier. I was like, do you guys think after... Because we've been saying for all this time, it's been going on. We've been saying, Bree, they are going to be able to use anything you put out on social media. They will use it. She kept saying, no, they won't. They can't do that. They can't do that. Blah, 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 right? But Bree is withdrawing and claiming it's... oh, jeez. That's crazy. But yeah, I truly think that's why. I think her attorney probably told her, stop posting. I mean, it's too late at this point. Trial's in, what, a week and a half. Yeah, I don't know if she is or she isn't pregnant. It wouldn't be surprising if she is, because they're clearly not using protection. According to the videos, I have not seen them, but people have told me. Thank you, love. This was just a couple hours. I just tan really, really easy. She had talked about it or seen it. Oh, has she talked? Oh, I don't know. I haven't been on today because I went right from having the baby, and then I was sent these, and so I wasn't going to go live today because I still wasn't feeling good. My back is killing me. But I got them. I was like, oh, let's go. So here we are. The witnesses for 2K are 2K, Mama 2K, and Bree. Yep, that is it. I did not need the listen. Me neither, Donna. I actually got to tell them, don't send it. You would be shocked at what I get sent. I just open it up. No trigger warning. I'm just like, oh, I did not need to see this. She doesn't. 13, she doesn't. Never will. I think she's talking about withdrawing from a substance and claiming it to be pregnancy issues. You're welcome, love. She's one that is that if she's pregnant, this will be a very long pregnancy. If she needs a 10-hour nap after a 2-hour visit with a child, how on earth does she really think she's going to be able to parent W and a newborn? Even though she's going to have a nanny and the mom and everything else. Like, it just doesn't. And mind you, she has said probably 5 to 6 times that her mom is going to move in, and that's never happened. So we don't know. We really don't know what's going to happen. Since Bree is a witness, does that mean she goes on stand? Yes. She will have to go on stand. She'll be questioned, cross-examined, vice versa with John. Mama 2K. I missed the first part of that, Tinsley. I just saw Ann Santos. You love in chat. Ain't having a new full job. No! Those jobs always getting in the way of our dang TikTok. I think I'm going to, this one I think because I can do it pretty quickly. I think I'm going to record in TikToks and I'll post them here. And then I'll also post the long version over on YT. I was just asked if this should be online. I said, yes, you're educated. Absolutely. You guys, this is public record. And so this absolutely can be online. And again, it's important for people to see, especially for young men to see that you guys, just like with Cortez. Cortez is going through the same exact issue right now. I've been following his story. It is amazing to see young men wanting to be very active members of their children's life, and it just sucks that they have to jump through all of these hoops because they have moms that are no, absolutely not. I'm not going to the trial. I get asked that all the time. That's so crazy. Yeah, I would never go to a trial that I have absolutely no relation to. Yeah, I would never do that. Yeah, Cortez, it just seems absolutely so. Thank you, love. Yeah, I'm struggling a bit. Cortez seems very sweet, and it's crazy that he went to court today, had a great court today. He goes to court on Friday, but I do find it kind of funny that all of a sudden the mom has now popped out and wanting to share her side in hopes that's going to help the case. Listen, the court of public opinion does not help the case. It doesn't matter how much any of us say that we think that 2K should get full custody or 50-50 custody, or Bree's people saying Bree should get, whatever the case may be. We have no say-so in all of it. The judge is going to determine that. Let's see, Libra. Hold on, let me look, see what your question was, love. Well, literally. What was your question? All I see is, I'd love to know the answer to this as well. Oh, wait, it's Mama T's question. Okay, let me find Mama T. Oh, absolutely. Yeah, will I read the transcript for the trial when it comes out? Yeah, absolutely. I'll go over all of that for trial. Then when trial stuff is done, then I'm done. Then I won't be going over any of this stuff anymore. Hold on, I gotta find Mama T's question. Wait. How you'll know Q out? No way, you did? We found him from TikTok, just making TikToks and fighting for his baby. And I just, I love young men that are fighting for their rights to their child. Okay, pin this please. Since Bree is a witness, okay, answer that one. Does this mean she'll be cross-examined? Yes. And if she lies and denies, what happens then? So if she lies under oath, numerous things can happen. She can be held in contempt of court, which could be a financial fine or jail time. Yeah, I just Q's thing I just happened to come across, and he just seems like such an amazing young man. And again, I work with, that's been my main thing is, I think she'll show up to court. Yeah, like I said, I'm genuinely curious to see what her attorney has to say, what her exhibit list is going to be, because 2K has not been the one out here doing all of the stuff, so I'll be curious to see. Yeah. Cortez is another, let me pull him up. He is another amazing young man who's fighting for even just visitation of his child, and the baby's mom has refused for that to happen. And he went to court last, and it is not today, but his hearing before that, and his baby's mom wasn't even there, but she had an attorney. And his baby's mom wasn't there because she was in jail for filing false police reports against him. He has 50-50, but baby mom won't allow him, yeah. He just wants to see his child. He's like, just let me see my baby. And TikTok community came in clutch and helped him get an attorney. But
to my lawyer's office. She done let me know she made all the copies, so I got my copies.
Why are you sideways, Cortez?
So we have court today. It is
This
August
is him.
11th. Like I told y'all a couple videos before, she tried to do a show cause. Well, she got granted a show cause because she tried to do a TPO.
So make sure you guys go follow him. Show him some good love from the Sock fam. Her evidence, Bree's evidence list is not out yet, so I don't know if they did get the Discord. It'd be very unlikely. Oh, you want to see Cortez again? It'd be very unlikely that it came through, according to AA. I don't know, but she did say that. First of all, she just put the subpoena in July 31st. Bree's Twitter is taken down for court reasons. I don't know. But this is Cortez here. Yeah, he's doing a great job. And again, the court system is really set up, you guys, to appease, pro-mom. But we're taking a lot of amazing fathers out of our children's life, and children need both their mom and their dad, as long as both people are sober, mentally sane, not abusive. They're good parents. His @ is, hold on, Self-Made QT. Here, I'll write it in here. He is absolutely great. And I love the fact that 2K also made QT. Oh, it's right in there. 2K messaged to him too, saying, hey, if you need any advice, let me know. And that's what I love. I love to see young men helping other young men fight this system and, being able to be a part of their kids' lives. It's amazing. It's mind-boggling to me that he shows up for court. Baby's mom does not show up for court because she's in jail for filing false charges against him, and the guy still didn't get to see his child. Absolutely, Chrissy. He sure is. He sure is. Right when I first started covering him and talking about it, a lot of people, and several people message me and say, listen, I'm following 2K. I saw you're doing this, or, Juris Social Worker, maybe can you help me, give me advice, blah, 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 whatever. He was giving people hope, and people are making big changes because of that. Oh, Carrie, well, I don't think she's not in jail now. She's out, but Cortez's baby's mother was in jail. Kaylee made a post I had sent to Angie earlier about how he was gonna lose. About who was gonna lose? That 2K was gonna lose? Listen. I don't think that the court's gonna take into consideration the fact that never mind. Listen. Not worth it. She definitely lied about getting on social media. Yeah. Yeah, there's absolutely no way. Yeah, listen. I just let her do her, and just hush and be respected. Just keep it moving. It's not even worth my time. There's almost zero chance. How did I fall? I was coming down my stairs out of my house, and my grand dog just hit me from the side. I just went flying. I honestly still don't know how I landed where I landed, because I fell hard and I landed hard, but yeah. And I'm not as oh jeez, you gotta be kidding me. Not as young as I used to be. I probably would have been able to bounce back from this, but yeah. Plus, I take forever to do things. I always just want things to go away. And so I probably should have went to the doctor when I fell and was completely black and blue, but I waited, and now here we are. But not a big deal. Yeah, she's definitely not fit to be around her own kids. I mean, neither is Santos. Let's not forget when she did have him and Santos was there. I think it's my tailbone, and I think it probably is fractured. But remember, he was like, oh, should we dump, baby W's sleeping, and he's like, oh, should we dump water on, like, he was wanting to do these things, he's wanting to, let's give him a bath on stream, like, what? What? No. What are you talking about? Oh. Oh. Steph, stop it. Oh my gosh, you're hilarious. What did you say? You're a mess. What do I love about you? Let's not forget he wanted to throw water. Yeah. Look, we're on the same page. Roll a towel up and shape it in a circle and sit on it. It hurts so bad. I know notifications that you love to come in here and try to get videos and stuff, but love bug. That doesn't work over here, okay? I'm not new to this, I'm true to this. Kick rocks. I love you too, love. Oh, I know you are. I know you are. She definitely being petty as fuck right now. Totally different though, saying Brie is gonna lose. Ugh. Ouch. Who's being petty? Oh, I don't know what time court was. And even if I did know, to be honest with you, that's not something I would put on my platform. Yeah. And Santos taking pics of baby W's. Yeah, that was so weird. The whole foot thing, that was crazy. Yeah. Love you, Carrie. Have a good night, love. I'll probably be right behind you. And the post he made with that look holding him. Yeah, he's just a weird dude. That's just, yeah, I don't know. I hurt my tailbone like that will snow with the kids, and the doctor said it takes very long. That's what I'm so nervous and worried about. Yeah, next Friday is the first day, Sonia. Their judge has ordered 5-year supervised visits for similar moms as Brie. I could absolutely see that. I could definitely see that coming. Now, let's be honest. So let's talk about it. So let's just say that's the outcome. We'll do a poll. Hold on, we're gonna do a poll really fast. If the judge gives her 5 years supervised visits, red, she'll continue to go. Blue, she'll stop going. What do you guys think? Red, she'll continue her supervised visits. Blue, she'll stop going. Oh, dang! Red, she'll continue her visits. Blue, she'll stop going. Oh, this is a wipeout. 3 things she'll continue. And 174. 4. Okay, 4 things she's going to continue. Then I have a question for the ones that think she'll continue. So red, you think she'll continue. Blue, you think she'll stop. So 5 for red. So you got, all right, 8, 7, 6, 5, 4, 3, 2, 1. So it's 6 to 204. Of those, okay, so then Box Mom says she hit the wrong one. So of the 5 that think she's going to continue, how long do you guys think she'll continue? Do you think she'll continue the whole 5 years? Or do you think at some point she would stop? I wonder if that will, let me see. She has made it very, very clear that she, 3 months max, that she absolutely will not move to Texas. She says there is nothing in Texas for her. 2 months. Stop eventually. New baby. Where'd that go? New baby will be the excuse. That's what I think too. Yep, absolutely. That's what I think. Yep, already has replacement cooking. Yeah, Texas is boring to her. Her words, not mine. There is nothing in Texas for me. I mean, let's not forget, you guys, Santos' daughter is also in Texas. So each one of them already have a child in Texas. And they want to be in LA. She already has stopped going, but yeah. In fact, she has. Yeah, her family's there, everybody. There's nobody in California for, I think California for her is a more of a status thing. You know what I'm saying? Yeah, that was my question. Whoever just said that is what's in Cali for her. What is in Cali for her? I really think it's just a status thing. Yeah, I'm going to, as soon as I get off, I'm going to download it. But I also think, like I said, I'm going to try to record it and put it up on put up on TikTok. Because the last few videos I've tried to record somehow just pause in the middle, and I can't unpause them. I have like 3 of them I'm trying to put up, so I'll have to record them. Yeah. So, alright guys, well, my back is absolutely killing me. And so I am going to hop off of here. However, first of all, I want to thank you. We're almost 600,000 likes, you guys. I want to hear what Ruby has to say about this. Wait, about what, Box Your Mom? You guys are absolutely amazing. Your little fingers must be tired. I so appreciate you guys so much. If I do get the, I will. Rotate, ice, heat. I do too. If I don't feel better tomorrow, I promised my daughter I would go in and get looked at tomorrow. Because, yeah, this is just not getting better. But if I get the, she totally believes her. You know what I'm saying? She believes the stuff that's being said. Plus, that's where anyways, that's a whole nother story for another day. But if I do happen to get her documents today, since they're due at midnight, I can go live again tonight. You're welcome, Missy. But if not, then we'll do them tomorrow, for sure. I will get there. Okay. I'll stay on until we hit 600K, because you guys are the best. Just because you asked. But I definitely appreciate you guys. I have no idea what her name is on Kick. That Kick is one platform I will never go on. Ruby has not been around long enough to be a witness. No. Just wait until tomorrow to read. Yeah, but like last night, I was in pain all night. I was up, just pacing. And so if I'm up, I might as well be distracted. Don't do anything other than rotate, heat, and ice. I wrote Tylenol. Yeah, that's what I've been doing. Well, I can't take Tylenol a lot because my liver. Oh my gosh, you guys are over 600,000. You guys are amazing. Can take a screenshot. But I've been taking Advil. I was only taking like 2 before, and then this morning, like I said, it was so bad. My daughter almost stayed home. She wanted to stay home from work because she wanted to leave with the baby. Because I went into the room and I was like flopped on the bed because my back was on. Oh, it was so bad. It was just on fire. Okay, Sonia, I had yours, and then Chiquita also sent one. So I gotta make sure I look at that for her. Yeah. So anyways, so we'll do that tomorrow. We'll read all that. Yeah, but it's something with I don't want to put all my medical stuff out there, but I'm not supposed to have a lot of Tylenol, but maybe before I go to bed, maybe I'll do that. I'll take both of them together and see if that helps. I like the Advil liquid gels. Those work really, really good for me. So I'll have to go get some. So, girl, if you need someone in the middle of the night, I'm here. Oh, no, I'm sorry, love. Listen, we can be in pain together, honey, okay? Yeah, last night I tried to do the... Jasmine also said, too, I could go sit in the hot tub. I happen to always forget that we have a hot tub. Well, I don't have a hot tub. She has a hot tub. They have a hot tub. But anyways, there's a hot tub. So I could do that, too. So we'll see. So... Well, shoot, we may just do a midnight live. I don't know. We'll see. All right, guys. I love you guys so much. Have a great night. You guys got to 615,000 likes. Rest your fingers. Do your fingers. Stretch them all out. And I'll see you guys either late tonight or tomorrow. I'm going to download it and get it over there. Love you guys. Have a good night. Bye.